and we'll keep this program moving along. It's going to be hard to follow the quality of that first panel, but I know that the panelists with me here are more than up to that task. My name is Bernard Dobransky, and I'm Dean at the law school at Ave Maria, which is one of the nation's newest law schools. I asked myself, why am I moderating this panel of all the panels? And the answer is because I think I know really nothing at all about antitrust, so that when I read the book, it was brand new to me and it made perfect sense. I didn't realize how revolutionary it was. But one of the, I said Ave Maria is one of the nation's newest law schools, and it's also, I think, one of the most successful. And one of the reasons, perhaps the primary reason, is that when we announced the formation of the school, we announced as the appointment of our first faculty member, Judge Robert Bork, which gave us instant credibility as an institution that was going to take legal education seriously and take it seriously in a way that should be taken seriously and hasn't been for a long time. And so it's been of great benefit to us. The judge isn't able to be with us all the time. He is a regular member of our faculty, but he comes out twice a year, once each semester, and he and I team teach a course required of all first-year students called Moral Foundations of Law. It's what he wanted to do. He didn't want to teach antitrust or any of those kinds of courses. He wanted to talk about something that was fundamental, the moral foundations of law. And so that's what we've been doing for the last 7 years. One of the things that I'm proud of in terms of our law school is that every student, in fact, every graduate, we've now had 5 graduating classes, has had the opportunity, that has had the benefit of taking a course called Moral Foundations of Law from Judge Robert Bork. I mean, that is truly, truly a benefit to those students who are fortunate enough to be there. And it's something that I'm very proud of. One of the greatest students has become me. I said we team teach. I'm just there to shuffle papers and move things along. The wit and the wisdom all comes from the judge. A few years ago, as we were doing the course, I think it was in the spring, the judge was a little baffled by the fact that students seemed not to know an awful lot about some of the things he had done in his career. I think it had to do with Watergate. And I pointed out to him as we were talking about this that he needed to keep in mind that these students, when he was having the Supreme Court nomination hearings in 1987, were 3 or 4 years old. And as bright as these students were, they weren't watching Supreme Court hearings in 1987. They were watching Sesame Street and things like that. And so it was not surprising that they didn't know an awful lot about his being Solicitor General or his involvement in Watergate or any of those sorts of things. But that led actually to a really interesting development of the course. We began doing every year, last class of the year, last Friday class, a conversation, very similar to what Ted Olson and Judge Randolph are going to do this afternoon. It's sort of an open line Friday with Judge Bork. The life and times of Robert Bork. You can ask him any question you want about anything, and he'll answer you. You may not like the answer, but he will answer you. And it's become, I think, the most popular part of the course. That last day, everything is open on the table for asking Judge Bork, from legal philosophy, from the movies he likes, to whatever. As we began preparing that, as I began preparing for that last class the first time we did it and tried to put it in context, one of the things that I was struck about, I've always realized this and understood it, but I was putting it together myself for the first time, and it has become something that has emerged from each one of these sessions, and that is the truly significant career that Judge Bork has had. How really important it has been in our American legal history and philosophy. In fact, he is one of the most important figures in our history, our legal history of this country. I'm preaching to the choir when I say this, but I think it needs to be said anyway. You know, most of us, law professors, lawyers, judges, hope to make some small contribution to some small area of law. That's what we hope to be able to do, have some impact. Judge Bork has had truly significant, seminal impact in 3 different parts of law. Obviously, in our understanding of originalism. General Meese mentioned this morning that famous Indiana Law Journal article, and of course it's one of the premier pieces of legal literature in the 20th century. And that's fairly obvious. We all understand how important his contribution is in that area. A subset of that, separate, I think it's discrete, is his writings, his thoughts, his wisdom on the intersection of law and culture and what that has done for our society. And then the third one, of course, is the one that's the subject of this panel, what he's done in the area of antitrust law. When the Antitrust Paradox came out, I mean, it just made people open their eyes. It wasn't just the precision of his logic or the penetrating depth of his analysis, the grace and elegance of writings. That's true in all of his writings. But it really made people say, look, we've been getting it wrong. It's so simple. Judge Bork has laid it out for us. Now, that's about as far as I can go because, as I said, my background in antitrust is very, very limited. But we have a wonderful panel here. I can't think of three people more qualified to talk about the antitrust paradox than our panelists here this morning. And I will introduce them in the order in which they will present. First of all, this panel actually really needs no introduction, but I will give them one anyway. Is the Chief Judge of the U.S. Court of Appeals for the District of Columbia, Judge Douglas Ginsburg. Judge Ginsburg was appointed to the court in 1986, and he became the Chief Judge in 2001. He took his undergraduate degree from Cornell University and his law degree from the University of Chicago in 1973. After graduating from law school, he clerked first for Judge Carl McGowan here in the D.C. Circuit, and then later on for Supreme Court Justice Thurgood Marshall. After the Supreme Court clerkship, he went to Harvard Law School, where he served as a professor for 8 years, and then he returned to Washington first as Deputy Assistant Attorney General for Regulatory Affairs in the Antitrust Division of U.S. Department of Justice, and then later Administrator of the Information and Regulatory Affairs of OMB, and then finally Assistant Attorney General of the Antitrust Division, the U.S. Department of Justice. And following that, of course, he was appointed to the D.C. Circuit by President Reagan. Second is the Chief Judge of the United States Court of Appeals for the Seventh Circuit, Judge Frank Easterbrook, who also serves as a senior lecturer at the law school at the University of Chicago. Before he joined the D.C. Circuit in 1985, he was the Lee and Brenna Freeman Professor of Law at the University of Chicago, where he taught and wrote in antitrust, securities, corporate law, jurisprudence, and criminal procedure. He published The Economic Structure of Corporate Law and over 100 scholarly articles. He also has served as co-editor of the Journal of Law and Economics and is a member of the Judicial Conference's Standing Committee on the Rules of Practice and Procedure. Before he joined the faculty at the University of Chicago Law School, he served as Deputy Solicitor General of the United States, and we had some more background in terms of his personal experiences there in the previous panel. He holds degrees. His undergraduate degree was taken from Swarthmore College, and he, too, is a graduate of the University of Chicago, also in the class of 1973. He's a member of the American Academy of Arts and Sciences, the American Law Institute, the Mount Pelerin Society, Phi Beta Kappa, and the Order of Coif. And our final panelist is Professor George L. Priest from Yale Law School. He's the John M. Olin Professor in Law and Economics at Yale. Before coming to Yale, he taught at the University of Chicago, SUNY Buffalo, and UCLA. His subject areas include antitrust, capitalism, democracy, products liability, regulated industries, insurance and public policy, constitutional law, federalism, state and local government. This is all in one semester, you know, and civil procedure. Do they still teach civil procedure at Yale, Professor Priest? I didn't. Special. Thank you. All right. Anyway, he has his undergraduate degree from Yale University and his JD from the University of Chicago, 1973. This is a class reunion that's going on up here. So, without further ado, let me turn it over to Chief Judge Doug Ginsburg.
Thank you all, friends of Judge Bork, Mrs. Bork, and classmates. As Dean Dobransky said, we quickly descended from the moral foundations of law to the economic foundations of antitrust. And I'm going to talk about Judge Bork's early contribution because it was so, I think, so pivotal in everything that's happened since. Those of you with even a glancing familiarity with the subject know that the Sherman Act was passed in 1890. It's very broad in its wording. It prohibits contracts, combinations, and conspiracies and restraint of trade, and makes it unlawful to monopolize any line of commerce. Highly open, very open-textured. And the open-textured nature of the Act inevitably vests the judiciary with considerable responsibility for interpretation. Judge Bork published an article called Legislative Intent and the Policy of the Sherman Act in the 1966 Journal of Law and Economics, when he was then teaching the subject at Yale. And the article, which then becomes a part of the Antitrust Paradox a few years later, examines the legislative history of the Act in depth. Professor Bork was candid about the difficulties inherent in the very concept of legislative intent. That's a quotation. Something that legislative intent, I remember a philosophy professor at UCLA once describing as making as much sense as saying, "We have a headache." Nevertheless, he thought the undertaking was justified by the need to counter the judiciary's repeated invocation of values that were quite unrelated to the debate that had informed the congressional enactment of the Sherman Act and lacked any legitimate economic rationale, and so were likely to produce real economic harms. To take an example, give you the flavor of the cases we're talking about, one, again, familiar with those of you who know the field, Fashion Originators Guild of America against the FTC, in which the Supreme Court had counted among the policies underlying the Sherman Act protection of, I'm going to quote because you wouldn't believe me otherwise, protection of, quote, the freedom of action of guild members not to reveal to the guild the intimate details of their individual affairs, close quote, protected by the Sherman Act. No less a light than Judge Learned Hand had asserted that the Congress intended the Sherman Act to achieve various socio-political aims, such as minimizing, quote, the helplessness of the individual, close quote, and ensuring the, quote, organization of industry in small units, close quote. Well, obviously, these policies and pronouncements are highly malleable. They can be invoked or not invoked to justify just about any result in any Sherman Act case. And indeed, as then Professor Bork pointed out, Judge Hand went so far as to state that enacting the Sherman Act, the Congress had, quote, delegated to the courts the duty of fixing the standard in each case, close quote. Bork's examination of the text and structure of the Sherman Act against the background of preliminary proposals and draft legislation, statements by senators and representatives, and contemporaneous understandings of constitutional and common law led him to conclude this: the legislative history contains no colorable support for application by courts of any value, premise, or policy other than the maximization of consumer welfare. Now, by consumer welfare, Bork here meant and I'm quoting, the maximization of wealth or consumer want satisfaction, close quote, known today as allocative efficiency, a concept that he thought the framers of the Sherman Act clearly enough grasped well enough. They didn't speak with the precision of a modern economist, as he said, but they had the gist of it. Bork also explained that the maximization of consumer welfare is the common denominator underlying the central prohibitions of the Sherman Act, the condemnation of cartel agreements first, of monopolistic mergers second, and of predatory business tactics third. He explained that the legislators used the term monopolize to refer only to those three prohibited activities, as opposed to monopoly, which might arise from superior efficiency and is not prohibited by the Act. According to Bork, quote, only a consumer welfare value, which in cases of conflict sweeps all other values before it, can account for Congress's willingness to permit efficiency-based monopoly, close quote. When this article was first published in 1966, the thesis was entirely novel. By 1977, it had become the conventional wisdom of the federal courts and still is today. That was the year when the Supreme Court, 1977, decided Continental TV versus GTE Sylvania and repudiated the position that it had taken just 10 years before in U.S. versus Arnold Schwinn. In the earlier case, the court had held that non-price vertical restraints imposed by a manufacturer on the distributor of its products after, quote, title, dominion, or risk had passed, close quote, was a per se violation of the Sherman Act. That is to say, regardless of its actual and possibly efficient economic effects. So you have a manufacturer or distributor imposing restrictions on the subsequent sellers, retailer or distributor or intermediate distributor, restrictions such as you may sell the product only at your location, not at additional locations, so that dealers are not in the same product line competing across the street from each other. In GTE Sylvania itself, a retailer of televisions had claimed that the manufacturer's locational limitation was a per se violation of the Sherman Act. And the Ninth Circuit expressly adopted Bork's thesis and rejected the multiplicity of values that the Supreme Court for decades had been reading into the Sherman Act. And the Supreme Court affirmed, holding that, quote, per se rules of illegality are appropriate only when they relate to conduct that is manifestly anti-competitive, and saying vertical restrictions promote interbrand competition by allowing the manufacturer to achieve certain efficiencies in the distribution of its products. Now, in emphasizing allocative efficiency over other values, the court implicitly, unlike the Ninth Circuit, which was explicit, implicitly endorsed Judge Bork's thesis. In his concurring opinion, Justice White attributed to the court the view that the Sherman Act is, quote, directed solely to economic efficiency. And he cited Judge Bork's article as the source of that position. The significance of the court's new Borkian position should not, I think, cannot be overstated and should not be underestimated. Tim Muris, who later became chairman of the FTC, wrote about it, saying, quote, the opinion was a ringing endorsement of the economic approach to antitrust law, close quote. And it was specifically a ringing endorsement of Judge Bork's manifestation of that approach. 2 years after Sylvania, in the case of Reiter versus Sonotone, the Supreme Court returned to the subject and looking at a class action brought under the Clayton Act by plaintiffs who had purchased hearing aids from a manufacturer that they alleged had fixed prices with its rivals and its retailers. This time, the Supreme Court relied expressly on Judge Bork's article and his appraisal of the legislative history of the Sherman Act, saying, well, the Sherman Act was the predecessor of the Clayton Act. The court concluded that the later statute, in providing a remedy for anyone injured in his business or property, covered, quote, pecuniary injuries suffered by those who purchase goods and services at retail for personal use, and then they went on to quote what was now available as the book, The Antitrust Paradox, of which the 1966 thesis had been incorporated. The court declared that the legislative history, quote, suggests that Congress designed the Sherman Act as a consumer welfare prescription, close quote. There you have it. In the NCAA against the Board of Regents of the University of Oklahoma case in the 1980s, the court had another occasion to embrace the consumer welfare thesis when it determined that the NCAA's limitation on the number of televised football games and its fixed price exclusive agreements with the various broadcasters violated the Sherman Act. Although the court noted that the arrangement adversely affected competitors' freedom to compete, as it put it, it ultimately based its decision squarely on allocative efficiency. So by the mid-1980s, Bork's thesis had undeniably changed the Supreme Court's most fundamental understanding of what the Sherman Act was all about. Now, I've not mentioned any other academics. No other academics weighed in to challenge Judge Bork until after the Supreme Court had adopted his reading of the legislative history in sonotone. He had been completely ignored. Since then, two distinct alternative theories of congressional intent have emerged. One is advanced by, among others, Professor Robert Land. That view is that the Congress's chief objective in the Sherman Act was the prevention of wealth transfers. Wealth transfers is the phrase, from consumers to business trusts, the forerunners of large corporations of today. Because the Sherman Act is an antitrust measure, and some legislators believed that large trusts were generally more efficient than small and medium-sized businesses, Land concludes that allocative efficiency could not have been the sole value underlying the statute. And instead, he argues that the act was intended to curb the market power of large producers in order to prevent their, quote, extracting wealth from consumers, close quote. The other interpretation is advanced most prominently by Professor Herbert Hovenkamp. He contends, based on the legislative history and the attendant political circumstances, that the primary purpose of the Sherman Act was the protection of small businesses, not of consumers. And he concludes that the Congress acted primarily to avert, quote, various kinds of injury to competitors, flowing mainly from the lower costs of more efficient rivals, close quote. Not very attractive alternatives, but there they are. The challenges, I should say, lodged to Bork's thesis by Land and Hovenkamp and those who agree with them are representative of the Academy as a whole. One commentator goes so far as to say that Bork's interpretation, quote, has been almost universally rejected by antitrust scholars, close quote. That's true. But the Academy has failed utterly to persuade the judiciary. And Bork's consumer welfare thesis has become one of his many enduring contributions to U.S. and really now to global antitrust law. Regardless of whether Bork's assessment of the legislative history is correct, the Supreme Court's endorsement of allocative efficiency as the fundamental value underlying the antitrust laws has had very important consequences. First, as a matter of administrability, the consumer welfare thesis has substantially ameliorated the practical problem of having courts choosing among multiple incommensurable and conflicting values. Even one of Bork's sharpest academic critics, Professor Christopher Grandy, acknowledges that Bork's thesis, quote, provides a clear and cogent set of rules that courts can apply in antitrust cases, and no other view of antitrust accomplishes this task as well, close quote. Second, the judicial adoption of Judge Bork's thesis has nearly put an end to the efforts of lawyers and the propensity of lower courts to manipulate the outcomes in antitrust cases by invoking highly plastic, subjective values of the sort instanced by Judge Hand, for instance. And third, by applying a single standard rooted in economic analysis, court decisions have become less arbitrary and more predictable, and no longer must businesses make decisions without knowing the standard by which their actions will later be judged if they're challenged in the courts. Finally, judicial endorsement of the consumer welfare thesis has, in my view, without doubt, led to a more efficient allocation of scarce resources, thereby increasing the wealth of the nation. And I think if then Professor Bork had not written the article and the book, these salutary developments would still be in the offing. Thank you.
One panel is not remotely enough to discuss Robert Bork's contributions to antitrust, or even a small portion of his magnum opus, the Antitrust Paradox. Members of this panel have carved off just a few slices. My slice is exclusionary practices, that is, predatory pricing, refusals to deal, tying, and many related practices that are said to make entry difficult and thus reduce the number of rivals. This is a subject on which much of what was deemed outre when Bork wrote is now settled doctrine at the Supreme Court and the normal way of thinking at the Antitrust Division and the FTC. To take even a bit of recent history, when Robert Bork was before the Senate as a nominee for Solicitor General of the United States, he had to promise the senators that he would not impose his idiosyncratic views of antitrust on the Antitrust Division and would allow the Antitrust Division to present its approach to the Supreme Court. I mean, how times have changed. Bob Bork was a product of the Chicago School and principally of Aaron Director, and he was its leading exemplar during the 1960s and 1970s, even though he was then living in exile at Yale. When the three speakers on your panel were students at Chicago, our teacher was Phil Neal, who was not a member of the Chicago School. Well, what are the intellectual tools that Bork used, and how did they lead to his diagnoses? One proposition, which Judge Ginsburg has just stressed, is that antitrust is about the promotion of social wealth, and usually that means consumers' welfare. It's never, ever about the promotion of producers' welfare. If it were about both, it would be utterly incoherent, and that's what the title of his famous book means, A Policy at War with Itself. If you try to be in favor of both of those things, all you get is complete incoherence. I mean, what's good for small dealers and worthy men, in Justice Peckham's phrase, is bad for everybody else. Competition is a gale of creative destruction. That's Joseph Schumpeter's memorable line. And it's by weeding out the weakest firms that the economy as a whole receives the greatest boost. So antitrust law and bankruptcy law are really just two ways of looking at the same subject. The goal of antitrust, to be more precise, is preventing the allocative loss that comes about when firms raise price over long-run marginal cost and thus deprive consumers of goods for which they're willing to pay more than the cost of production. Bork also stressed productive efficiency, joining Yale Brosen among Chicago colleagues in arms. An emphasis on efficiency implies a program for antitrust law. That is, look for situations in which firms can increase their long-run profits by reducing output. It also implies accepting another of Schumpeter's prescripts, that sometimes one large firm is best when that firm can produce most cheaply. So how do you go about this? Well, you want to look for situations in which self-interested people can do consumers dirt. You want to assume people are behaving rationally. When will a rational, self-interested producer find that money can be made by restricting output? That's not to say that everybody is rational. Instead, the point is to say that the law's sanctions are directed to rational people. Those who figure out how to lose money by restricting output need not be penalized. Their conduct is self-deterring. For example, antitrust law doesn't impose penalties on people who make bad decisions about designing products. The producers of the ad sold did not have to pay an extra antitrust penalty, even though they drive consumers away and reduce output. Now, that understanding has a really big effect on how we think about exclusionary practices, because many of them, predatory pricing, for example, can succeed only if somebody, or lots of somebodies, is behaving irrationally. Mistaken attempts to predate confer benefits on consumers. They get the benefit of lower prices now. And since it's mistaken, it's self-deterring, so the law should ignore it. The other way of understanding low prices is that the low prices stem from efficiency. And if you've got a choice between a tactic that may be efficient or may be inefficient but is self-deterring, what the law should do in either of those two situations is nothing and nothing. Does nothing for different reasons, but it gives you a clear prescription. What goes with this as well, and is an important part of Bork's thinking, is that one should be exceedingly suspicious of claims that new products or low prices or novel means of distribution injure consumers. Innovation is something that we ought to be promoting. Claims that the long run will depart from the short run are easy to make but hard to prove. As Yogi Berra put it, it's always hard to make predictions, especially about the future. Instead of making predictions that are impossible to test and that will injure consumers if you're wrong, wait and see what happens. If monopolistic prices happen later, prosecute them then. That, too, has become the norm in the Supreme Court's jurisprudence following Bob Bork's proposals. In days gone by, people talked about using leverage to extend market power to new products. When Bob Bork exploded the leverage myth so completely that even Don Turner had to agree with him, and the Supreme Court abandoned the doctrine, new claims arose based on, say, arguments about physical bottlenecks, the last mile of wire in telecommunications, for example, or complementarities, such as the relations between software and computer operating systems. Those kinds of arguments demand that holders of market power cooperate with rivals, a la the joint ticket in the Aspen skiing case, which in 1985 was the very last gasp of the old Harvard School of Antitrust. Most of those theories bit the dust in 2004 in Verizon against Trinco, where the Supreme Court held that even a monopolist has no general duty to cooperate with rivals. The court concluded, as Bork had stressed for his entire career, that the main goal of antitrust is to compel firms to be rivals, and that cooperation is a thing to be feared rather than welcomed. Now, the big problem when you're thinking about exclusionary practices is that all competition seeks to undercut and exclude rivals. That's what any good firm is doing. And of course, efficient production and lower prices are the best exclusionary tactics, hardly to be condemned on that account, but also hardly the only ones. People have to organize production in a particular way, and they do it with contracts, they do it with agreements, and so on. One can tell stories. The classic story is the predatory pricing story told about Standard Oil, that it was just reducing prices so low that other firms had to leave the business, and then it could jack up prices as a monopolist. Any of these stories entails three possibilities. It could be exclusionary in the sense that other firms are kicked out, but also beneficial for consumers because the firm is making a better mousetrap or selling the same old mousetrap at a lower price. It could be exclusionary in the sense that it kicks out rivals and there's no better mousetrap, so in the long run, when the rivals are gone, prices will rise. Or it could be beneficial to consumers in the sense of being a mistake, and then it's self-deterring. Well, how do you distinguish among these three possibilities when somebody points to an unusual business practice? How can courts tell the difference among them? Well, they can't. Every indicator of exclusion is also present with efficient competition. Both predators and efficient producers undercut rivals and gain market share. What distinguishes exclusion from competition is what happens in the future. The kind of exclusion we would like to get rid of will lead to monopoly prices in the future. The kind of efficient conduct that we like to keep will not lead to higher prices in the future. But judges are no better than the rest of us at predicting the future. I can tell you my own predictions are no better than yours. My colleagues and I spend most of our time on cocaine prosecutions, employment discrimination, and the myriad other subjects that are within federal jurisdiction. We can't hope to emulate students of industrial organization. And my friends who are students of industrial organization are themselves no great shakes at prediction. Consider for a moment the claim made by the Antitrust Division that Microsoft's provision of Internet Explorer at zero marginal price would drive other browsers out of the market. Now, I know Bob Bork sided with some of Microsoft's rivals in this fight, but I want to praise the work of Bork the academic rather than Bork the consultant. What happens in the browser wars is not interesting unless it's accompanied by a claim that after extinguishing its rivals, Microsoft would raise price and decrease output. So, what's happened? Certainly, Internet Explorer's market share went up, and today it enjoys the dominant position that once belonged to Netscape. But did Microsoft raise price and curtail output? Of that, there's no evidence. Indeed, Franklin Fisher, who provided the principal expert testimony for this aspect of the government's claim in the Microsoft case, said as much. He called the provision a tie-in and added that so far as he could tell, it had no adverse consequences on consumers. The government wanted it banned just because it was a tie-in. But we're back to Bork. Bork lampooned the theory of tie-ins by saying, well, you might as well argue that automobiles are all per se violations of the antitrust law because they all come with doors. Cars didn't used to come with doors. Think about the original Fords. They were door-free. Indeed, they were top-free. They lacked a lot of other things, right? There were reasons why automobile manufacturers began to put doors on their cars, but it didn't have anything to do with trying to injure consumers. There are reasons why producers of operating systems began to add browsers to their systems, but it didn't have anything to do with injury to consumers. The Antitrust Division effectively made a prediction in the Microsoft suit. If Microsoft is allowed to bundle Internet Explorer and undermine Netscape, it will obtain a monopoly and be able to raise prices in the future. And that prediction has been falsified. Today and for the foreseeable future, there are a whole bunch of other distinctive browsers available to consumers, and they're all free. On my computer, I've got Firefox, Opera, OmniWeb, and Safari installed. Now, OmniWeb and Safari are the most interesting, really, because they run only on the Macintosh operating system, which holds a very small share of all operating systems. And yet a chance to compete for a share of that small market has induced the development and distribution of new browsers. And last week, by the way, Apple started distributing a beta of Safari for Windows. Competition turns out to be very hardy. That was the core understanding of the antitrust paradox. If you try to stop competition, you're almost certainly going to fail. That most predictions that practice X will stop competition are likely to be bad, and that trying to sort the good from the bad is not something that we can do. Think about some of the other predictions. There was a prediction made in the Zenith antitrust case, which the Supreme Court decided as the Matsushita case back in the 1980s, that low prices charged by producers of Japanese television sets and other electronics would drive other firms out of the market, monopolize things, the price would be high for us all. The prediction was ridiculous for reasons that Bork gave, and again, it's been falsified by experience. The prices of consumer electronics have continued to go down. Any effort by the Japanese producers to raise the price would simply have knocked themselves out and led to a market advantage for other producers. I tend to think, as did Bork, that the future will be like the past. The ability of judges and other regulators to second-guess markets has not improved, and it's not going to improve. Antitrust economic models may have improved, but it's real-world performance that matters. If choose better regulators or educate the judges has not been a successful prescription for the past 115 years, it's not going to be a successful prescription tomorrow. And that's not a matter of faith in markets or some quasi-religious creed, but of evidence. We want to look for suits about exclusionary practices that were actually filed and nailed bad practices, you count those as successes, and tote up the gains of those suits against the antitrust suits actually filed that nailed beneficial practices, right? Those are the false positives. Only if the gains from one exceed the losses of the other would we think that pursuing exclusionary practices is a good idea. And aside from pointing to the AT&T divestiture in 1982, something that was probably going to happen anyway as a result of changing technology, regardless of what the antitrust enforcers did, very few people are willing to claim even one success in this line of work. Another way to put this, and this was fundamental to Bob's understanding of antitrust, is that judges and enforcers have to be very wary of claims that take the form, here's an economic model in which bad results can happen. Let's use the legal system to find out whether they happened. That approach just assumes away the costs of false positives. And because those costs are high, that's what the errors in antitrust over the last century tell us, we shouldn't seek to test economic theory in the halls of government, where mistakes may be inflicted on the populace. one wants to test models the professional way by gathering data, running regressions, and publishing in professional journals. Today's Supreme Court has seen things Bob Bork's way on most exclusionary practices. I've mentioned Trinco, no compulsory cooperation. And I've mentioned Matsushita, which all but abolishes predatory pricing doctrine. This term, in the Weyerhaeuser case, the Supreme Court extended that view to claims of predatory buying. The Ninth Circuit had upheld a large damages award imposed against a firm on the theory that it had bought too much of its input. And as a result of buying too much, more than consumers wanted to buy from it? As a result of buying too much, it had driven the price up and injured rivals. And the Ninth Circuit had said, oh, well, you don't want to be injuring rivals. It seemed they had forgotten since their opinion in Sylvania, whatever they knew in 1977. The Supreme Court reversed unanimously. That is, of course, what usually happens these days when it reviews decisions of the Ninth Circuit. Back in the 1980s, Jefferson Parish against Hyde made market power a condition to any claim of tying. It effectively abolished the per se tying doctrine. And last year, Independent Inc. extended that rule to patented products, abolishing the old doctrine that patents automatically show market power. Now, that was something that was a particular topic of Bob Bork, the patent equals market power equation, and also of Ward Bowman, his comrade in arms at Yale. The whole Chicago School of Antitrust at the time was at Yale. It was Bob Bork, Ralph Winter, and Ward Bowman. And they were thoroughly vindicated in the Independent Inc. case. And as a general matter, as an umbrella rule, Spectrum Sports holds that only a dangerous probability of success in getting a monopoly justifies any exclusionary practices claim. And it's almost impossible to show a dangerous probability of getting a monopoly because the future lies ahead. So this list could go on and on. There's only one respect in which Bork's position about exclusionary practices has failed. His main worry about exclusionary practices was not what private firms do. It was about the use of government as an agent of exclusion. Entry barriers created by the government can't be undermined in the market. Now, the Supreme Court has shown some cognizance of this when the part of government at issue is the courts. It may be possible these days to make out an antitrust claim based on predatory litigation to raise rivals' costs. One thing judges can see is that a lot of suits being filed really shouldn't have been filed, and discovery is really, really expensive. The Supreme Court emphasized that in an antitrust case just this year. So one can use antitrust law itself to impose costs on rivals and injure consumers, and the justices are now cognizant of that. But the court has not overruled Parker against Brown, the granddaddy of other uses of government to restrict competition, and it isn't likely to. The antitrust laws are not a warrant to undermine other statutes or set up an inquest along the lines of Lochner, in which statutes have to prove their value in order to pass muster. So only 90% of the Bork program is in force today. But that's an astounding success for an approach that was branded as kooky in the 1960s, the time of Brown Shoe and Vaughn's Grocery. So 3 cheers for Bork. If only he'd achieved that much success in constitutional law. Thank you.
Well, it's a great pleasure to be here, especially a pleasure to be with my distinguished classmates. It really is fun to have classmates that have real authority, as these two do. But there's an additional reason that I'm happy to be here. I'm pretty sure that both Doug and Frank, when they went into academia, were offered positions at Yale Law School, but turned them down. Frank went to Chicago, Doug went to Harvard. Some years later, when Yale was trolling at the lower levels, I got an appointment at Yale, and Bob was there at the time, although I didn't get to know him very well then. But after he left, I was able to inherit his antitrust course. And so at Yale Law School, I'm Bob Bork's successors. For all the horrible things Bob continues to say about Yale Law School, now he's added the Yale Club in New York as well, but he says he continues to say terrible things about the Yale Law School, but he remains an important and dominant presence there today. He certainly does in my class intellectually. I would like to think that my antitrust class resembles the course he would teach, but he also has an important symbolic presence at the Yale Law School and in my class as well. Typically, my class has about somewhere between 80 to 100 students in it, and so it's taught in one of the two large classrooms at Yale, typically in the same classroom year after year. And in this classroom, right on the wall, exactly where that exit sign is at the door behind you, is a portrait of Bob Bork. And so as I'm teaching the class, every time I say something and look up, there is Bob looking at me, and with the sense of his evaluating what I'm doing. It's a wonderful portrait. It's perhaps missing his sense of humor and does not show the lighter side. It's somewhat stern and severe, but it certainly does have an effect in keeping me in line, although I'm pretty reliable, but it also has an effect on the students. This happens usually only in the first of the class of the course, but any time a student makes an argument based upon barriers to entry or claims that a monopolist is able to leverage monopoly power from one market to another, or claims that there are important foreclosure problems by this industrial practice, I simply refer them to Bob Bork's portrait, ask them to look over their shoulder at Bob Bork, and what is a stern portrait turns into a scowling portrait, and it has a wonderful influence on their later performance and understanding of the ideas. What I would like to do in the brief time I have today is to place the book Antitrust Paradox in the context of the Chicago School. I think to understand Bob's contribution, it's necessary to see how it fits within the Chicago School and the extent to which, though I think it's a limited extent, the extent to which it derives from other work within the Chicago School. There are many outside of the Chicago School, and even some within the Chicago School, that tend to minimize Bob's contribution in Antitrust Paradox and in the article that the legislative intent article that Doug talked about, by insisting that Bob's principal economic ideas had already been developed before Bob wrote the book and had been developed by Aaron Director and Aaron Director's colleagues and really assistants such as John McGee and Lester Telser and the like. Now, I think that, as I'm going to try and explain, I think that's totally misunderstands what Bob's contribution is, although Bob, in Antitrust Paradox, as you'll see, goes out of his way to acknowledge Aaron Director's brilliant and seminal thoughts, especially with regard to vertical practices. But basically, the Chicago School, I would define the Chicago School as having, at least the Chicago School of Economics, as having a fairly limited set of principles, of ideas, which Bob did use and which Bob did expand. One of those is that markets are generally highly competitive. So there's a presumption that markets will be competitive. Secondly, a presumption that the practices of any single firm, and this follows from the presumption of competitiveness, the practices of any single firm in the market are generally mechanisms of advancing the interests of the single firm, but advancing those interests by advancing the interests of consumers. There are from that basic principle, the various ideas that Frank described dealing with vertical practices follow, such as there's only a single monopoly profit. 2, it's impossible for a firm to leverage monopoly power or market power from one market to another. 3, what is often criticized as foreclosure is really the result, as Frank explained, really the result of competition. Those are the basic principles of the Chicago School. Now, if you've read Antitrust Paradox, you'll see that those are the principles of the economic basis of antitrust, of the application in Antitrust Paradox as well. But what Bob does in in the book Antitrust Paradox is take those basic ideas and apply them rigorously and exhaustively to the antitrust canon as it existed at the time that he wrote the article. So, for example, again, Doug has emphasized Bob's advocacy of the consumer welfare standard, and Bob showing that the consumer welfare standard enhances not only consumer welfare but also the wealth of the country. Again, that's implicit in the Chicago School approach. Bob applied it systematically throughout, both in the legislative intent article and throughout the book in Antitrust Paradox, and it was that broad-scale application I think that led it to be triumphant in antitrust as it is today. But Bob's application of those simple ideas of the Chicago School went far beyond that. For example, Bob took apart in this book the concept of incipiency and the approach of under the Clayton Act of trying to stop anti-competitive developments in quote in their incipiency. He was a scathing critic in the book of basically everything the Federal Trade Commission had done during the 1950s and during the 1960s under the guise of populist enforcement of the antitrust laws. He demolished entirely the concern, as Doug has explained, the concern for the protection of small business over consumers. He demolished, again, the concept of barriers to entry as aiding the analysis of antitrust offenses. He again demolished the concept that was common at the time of that because of that some anti-competitive actions occurred and were successful because of quote imperfections in the capital market. Again, taken apart. It's not a part of the antitrust canon anymore. Those general principles can all be attributed to Bob's effective championing of the principles of the simple economic principles of the Chicago School in the much more complex and rich antitrust paradox. But it goes beyond that. Bob, I think, it was Bob's explanation in Antitrust Paradox that has changed the direction of merger law entirely. Frank referred to Brown Shoe and Vaughn's Grocery. Again, those decisions are inconceivable now as a consequence of Bob's work. More generally, Bob explained the competitive benefits of competition between independent businesses. And he's had the greatest effect, as Frank has described, on single-firm vertical practices. The book shows the virtues of attaining size by internal growth. It, as Frank has explained, again, demolishes entirely the concept of predation by showing that it's factually implausible in almost all contexts. Although he has, as Frank has pointed out, there has not been the same success with the single practice of resale price maintenance. The world has changed with regard to manufacturer controls over distribution practices to the benefit of consumers. And as Frank has said, the former concept of leveraging monopoly power from one market to another and the fallacy of the concept of foreclosure, I think, are all attributable to Bob. Also, as Frank has pointed out as well, the previous manifold objections to tying arrangements have dropped away as a result of his analysis, not to mention his criticism of the Robinson-Patman Act. Again, when we took antitrust law, Robinson-Patman Act was still a live statute, and the intricate details of the various sections of the Robinson-Patman Act were subjects that we had to study. Today, the Robinson-Patman Act is essentially a dead letter. Now, I want to add one other point about this, about the influence of Antitrust Paradox. The influence stemmed, again, from taking these simple ideas of the Chicago School and applying them with rigorous analysis and thoroughness to all of the different areas of antitrust law and showing how these economic ideas could explain and explain how the cases ought to have been decided, though they hadn't been decided at that point. But I think in that way. But I think the influence of the book derives from one other feature of it that goes beyond Bob's powerful presentation of economic analysis. In rereading the book, as I did this last week, I found passages that actually I had ignored or neglected when I first read it, and I think this is probably true of many of our generation because we were focusing on the economic analysis of the case law rather than on the passages that I think probably in retrospect had the greatest effect in securing the agreement of our courts to Bob's approach, and that is that Bob integrates his explanation of economics and his advocacy of consumer welfare as a standard of antitrust law with a discussion of the institutional limitation of courts. He includes discussions of the virtue of law as law versus law as political decision-making, and how the consumer welfare standard that he's explaining is consistent with that view. This is a link that I had missed before between Antitrust Paradox and Bob's other work, such as Tempting of America, that we just discussed. Bob presents a justification or an explication of the types of cases that are fit for judicial decision-making, and why the consumer welfare standard is the only standard for the resolution of antitrust issues that is consistent and preserves the integrity of the law and the integrity of courts as judges, not as political decision-makers. I think that aspect of the book, ignored largely by economists and economic types, it was really very important for convincing courts to adopt his view of the world and his view of these cases. And his influence, as both Frank and Doug have pointed out, was extraordinary. Those of you that are just now reading, I see a lot of students in here, if you're just now reading the book, you may not notice this, because Bob, after I think maybe 10 years or 12 years after the book was originally published, he went back and added more material dealing with case law that had been developed by the Supreme Court and other courts thereafter. And so you wouldn't really know this if you read the current copy of the current edition of Antitrust Paradox. But it was because these cases hadn't been decided when Antitrust Paradox was first published. But the point I want to make is the point really that Doug made as well. The entire current corpus of antitrust jurisprudence can be attributed to Antitrust Paradox and the articles that preceded Antitrust Paradox. NCAA, Matsusha, Ryder versus Sonotone, Aspen Skiing, which we may talk about again, BMI ASCAP, Jefferson Parish Hospital, the Brook Group case, which he argued in addition, State Oil versus Kahn, the Microsoft case too. Even the D.C. Circuit Court of Appeals decision in the Microsoft case was heavily influenced by Bob, as Frank says, the academic, even though he was taking a different side in public affairs. The Weyerhaeuser case as well. Now, none of these cases cite Aaron Director or cite Lester Telser or cite John McGee. What they do cite is Bob Bork and Antitrust Paradox, or their ideas derive clearly from Bob Bork and Antitrust Paradox. So the influence of this book has been extraordinary, and I think really certainly unprecedented in the antitrust field, but I think unprecedented in other fields as well. I want to end by referring to, as some did in the preceding period, by referring to Bob's appointment to the Supreme Court. When he was nominated for the Supreme Court, I had an honor that was denied my classmates, both of whom were then sitting judges, and that was I had the opportunity of testifying on his behalf, or testifying in favor of the appointment. The controversy of that period, again, I guess many of you were children or not alive or watching other shows. But the controversy of that period, which is 20 years ago, really doesn't cease. On occasion, I serve as an expert witness, and the one item in my resume that the opposing attorney will always drill in on was my testimony in the Bork hearings. But it's a badge. It was a badge of honor for me to have that chance. What I want to say about this is that the failure of Bob's confirmation by the Senate really had nothing to do with Bob. Again, those of you that were too young to know this or to see what was happening, I think it's important for you to know this. It really had nothing to do with Bob. It had nothing to do with originalism. It really was it was a function of the weakness of the president. President Reagan's nomination of Bob followed very shortly after the revelation of the Iran-Contra affair. And since the Senate could not attack the president except verbally, directly, what the Senate did was to attack the president's appointees as a way of undermining the president. And it's really quite similar to what we see today in the experience of John Bolton at the United Nations or Paul Wolfowitz at the World Bank, and perhaps Alberto Gonzalez soon. We have a president that is weak because of the failure or the lack of success of the Iraq war, and so the Congress fixes upon, and opposing politicians fix on some minor feature of a candidate's background and attempt to attack that candidate, attempting to undermine not only the candidate's just a tool, but to undermine the president by so doing. Now that's what happened at Bob's hearings. But in that regard, I think it's important to note, and it's been mentioned several times here, that the principal source of the attack was this Indiana Law Review article, which derived from a speech of Bob's. It was not the Antitrust Paradox. The Senate at Bob's hearings didn't come close, except that some of the supporters did, but including me. But the senators that were active in attacking Bob at those hearings would not touch the Antitrust Paradox because they couldn't touch the Antitrust Paradox. They could not possibly respond to either to the power of its logic, of its analysis, of its application to the law, or to the influence that the Antitrust Paradox was continuing to have and still and had had by the time of those hearings at the Supreme Court. But all was not lost. It was unfortunate, I think, for the country that Bob's appointment was not confirmed. But I say all was not lost. Bob on the court certainly would have changed the law more personally and more directly. But the law has continued to be changed, especially in the antitrust field, by Bob indirectly through the influence, the transformative influence of this great book. Thank you.
Thank you very much, Professor. And in the short time remaining, I'll first ask the panelists if you'd like to add any rejoinder to the comments of your colleagues or any additional comments you'd like to make. Yes, Judge.
I just have one very brief comment. George Priest said the Robinson-Patton Act is dead. One has to be careful about how it died because this produces a conflict in Bork's jurisprudence. On the one hand, the Robinson-Patman Act went away when the Antitrust Division and then finally the FTC stopped enforcing it. And there's no problem of democratic legitimacy in prosecutorial discretion. To the extent the Robinson-Patman Act is a dead letter because judges have come to the conclusion that it was a mistake and pulled the plug on it, which is essentially what happened in the Supreme Court in the great Atlantic and Pacific Tea Company against the FTC, Bork himself would say that that was an illegitimate step. In this respect, Bork and Holmes are together in the idea that if Congress wants to go to hell, the judge's job is to help us get there quickly and efficiently.
Thank you. Professor Priest?
I just wanted to make reference to one statement that Frank made. I've never heard Frank. It's not wrong, but there's one slight change I want to make that I want to suggest that also shows Bob's influence. Frank described the Aspen skiing case as the last gasp of the Harvard School. Actually, I've recently written a paper about the Aspen skiing case that really is very close to a paper that you wrote in the 1980s, which was a very perceptive paper. But in Aspen skiing, the Supreme Court doesn't cite anyone from the Harvard School. They cite Bob Bork. The principal source for the decision in Aspen skiing are pretty obscure passages in Antitrust Paradox, which are misread by the Supreme Court to find a ski company guilty of monopolization. Now, it's very clear from what the Supreme Court does in Aspen skiing that they're taking Bork. I mean, they're reading the minutia of Antitrust Paradox and trying to apply it in order to determine when a change in distribution practices can be monopolistic or not. Now, I don't think Bob would have agreed with the application. I haven't talked to him about it, but I would doubt he would agree with the application at all. And as Frank has said, again citing Bork, the Supreme Court has reduced Aspen skiing to near triviality in Verizon versus Trinco. But Aspen ski, even the cases the court gets wrong, they cite Bob Bork as their principal influence.
Judge Ginsburg.
Well, there's one decision that we're all waiting for yet this term, Legion Leather Goods. And if the court overrules Dr. Miles and takes Bob's advice and applies it to that case tomorrow, I mean Thursday, I guess it is, when they're hearing or announcing, that will be the last victory. It will, the program will have been entirely enacted into law at that point. If it doesn't happen this week, it will not happen for a generation.
Question?
Mark Holmes from Washington. I'm wondering if the panelists have given any thought to the Bork project in antitrust and its relations to stare decisis and statutory interpretation, which hasn't been discussed here, but is obviously relevant not only to antitrust but to a lot of other areas of law that are based on statutes and have an enormous judicial component to them.
Judge Ginsburg?
Well, the court has, in some of its decisions, explicitly overruled prior decisions, as I'm hoping it will this week. It went through a period of 10 years in which it took one vertical practice after another and said they would no longer be treated as per se violations, but subject rather to the rule of reason. The court is doing this. It's actually acting very much as a common law court because of the open-textured nature of the statute. And its one real failing in this regard, I think its willingness to reconsider those precedents is a virtue. Its one real failing has been its refusal for 30 years, Frank, to take a substantive merger case. What was the last one?
General Dynamics, 1974.
Okay, so more than 30 years now. And that's left to the lower courts a great burden of self-discipline. Fortunately, the government enforcement agencies have been quite good about not enforcing the precedents that are still on the books. When I was Assistant Attorney General, I did not allow the staff to cite the brown shoe case and a few others like Vaughn's Groceries. But nonetheless, Rick Rule and I read every brief before it went out because we had to cross out the citations to those cases. It's in the nature of litigators to use those cases, and it's unfortunate the Supreme Court has not revisited the question.
Judge Easterbrook?
Just a brief comment on the stare decisis question. I don't think it's ever been a part of Bob Bork's jurisprudence that interpretations of statutes are inviolate. Indeed, one wonders why the rule isn't that one should always interpret statutes correctly. Prior judicial errors aren't a very good reason for bungling statutes if we're now sure that it's a bungle. Cases like Creative Leather against Ligon, whether Dr. Miles will be overruled, are very difficult, not simply because there's a stare decisis component, but because the law, Congress has made several statutory changes. It first authorized resale price maintenance if there were state laws authorizing it, and then it repealed that. And the last time it got close to overruling Dr. Miles, the court said that Congress's repealer of the state exemption is also something that had to be taken account of. And of course, that's not just legislative history, it's a real enactment. So it's always conceivable that what we will hear on Thursday is that Dr. Miles has effectively been enacted by indirection. And Bob will be the first to tell you that the courts should not, in the guise of creative interpretation, try to undermine things that Congress has actually passed into law and the President has signed.
Next question.
Yeah, John Lott. Bork's book kind of came out right at the zenith of the Chicago School's influence in terms of academia. And if you look at it afterwards, there seems to be a real dichotomy between kind of Bork's influence on the courts and kind of the Chicago School's influence in, let's say, economics departments around the country, where you've had almost immediately after Bork's book, you had kind of the rise of game theory with Krebs and Wilson and all these other ones, which kind of would go through mental mind games to show possibility theorems about what could happen. I know Frank mentioned the importance of empirical evidence in terms of debating these things, and I realize that it's mainly like case studies rather than any type of systematic evidence there. But how long or is there a limit to the influence that, let's say, Bork's work represents for the Chicago School on courts, given that so much of academia seems to be tied up with justifying these possibility theorems that could go there, and in some sense, if you accept that, kind of undermining a lot of the basic claims. And I just want to make one other fast comment, and that was for George's discussion about the confirmation hearings. Just mention I have my own research that indicates that the smarter the judge, the harder the time that they have to get confirmed, and maybe that would show kind of an extreme case there. But anyway.
John, it's precisely the fact that so much modern I.O. is game theoretic, possibility theorems, and the like. As George Stigler was fond of saying, there's no proposition so stupid you can't find a respectable economist to support it. It's precisely because that's the tendency in modern industrial organization that Bork's approach continues to be so persuasive. Judges are not capable of holding more than two things in their mind at once. The idea that they will be following the latest developments in the stochastic calculus is extremely implausible. The core Chicago school, the one developed by Aaron Director and continued by Bob Bork, is one that urges fairly simple propositions, simple-minded enough even for a judge, and then urges that they be tested against our knowledge of the world. And had Microsoft's ploy with Internet Explorer succeeded in wiping out the rest of the browsers, had Firefox not come into existence and so on, one would say that an important proposition of the Chicago school had been falsified by the world. And one has to take that kind of experience as reflecting on the utility of simple rules. But every time a simple rule gets confirmed by experience, it seems to me that suggests that we continue using it.
Let me just add one thing. Academics like to believe that what is current in the literature is going to become policy at some later point, but it doesn't. It seldom happens. In fact, the Chicago school may be, or the Chicago school approach may be less influential in the journals, but it's certainly influential in terms of public policy, not only in the courts and in antitrust law and I.O. industrial organization practice as we see it, but also in terms of monetary policy. That is, the Federal Reserve are all monetarists now, and the rest of the world is too. I would say the one other feature of Bob's work and of the Chicago School that has been validated is the recognition by virtually everyone interested in these issues that markets are much more competitive than might have been thought in the 1950s and the 1960s. And by loosening up, changing these restrictive antitrust rules that had been enforced before, the country has experienced tremendous economic growth, and stands to see even greater competitiveness in the future with the rise of globalization. So I think the Chicago School has been totally vindicated, whether the current journals bear that out or not.
Judge Ginsburg.
To the extent that the Chicago School means the importation of economic analysis into our understanding of a law designed to benefit consumers and the nation economically, there's the lurking danger that courts will start making decisions based on the most recent issue of the American Journal of Industrial Organization. I agree with Frank that it's unlikely that judges will aspire to that level of sophistication, thankfully, but it's also likely, I think, that simple ideas, contrary to Chicago simple ideas, are being taught and will take hold, and that this is what students are learning today, not just the stochastic calculus, but simple ideas like raising rivals' costs and things like that. And those will find a foothold in the courts if that's what the Academy is propagating. Herb Hovenkamp's excellent book, Enterprise in American Laws, 1837 to 1937, is a demonstration of the thesis, very powerful demonstration of the thesis, that the understanding of economics reflected in the law lags about 25 years from what's happening in the Academy. The introduction of marginalism, one thing after the other, and I don't expect that will stop.
Okay, last question.
My name is Stephen Wallach. I'm a patent lawyer. I'm wondering if there's anything to be said about the influence of Judge Bork's ideas at the Antitrust Division of the Justice Department. The one situation I'm most familiar with is something called the 9 no-nos, which is a list of mostly patent licensing arrangements that the division considered per se violations, were built up largely through the 60s and 70s, and then a few years in the 1980s magically and perhaps blissfully went away. You have comments on that situation or others?
Judge Ginsburg?
Well, Bill Baxter came in 1981 and tore up the 9 no-nos. It was as simple as that. By the time I got there in '83, they were not only not mentioned, they were unmentionable.
That's to say the department is now listless.
A last comment, Professor Priest?
No.
Okay.
I can't beat that. I can't beat that one.
Well, on that note, we'll end. I want to thank you all for your patience and your attendance. I really want to thank the panelists for taking the book, the whole field, and capturing the essence of it, the genius of Bob's work here, and the real impact it's had, and doing it in 45 minutes. I really appreciate that. We take a short break, and then right across the hall in the grand ballroom is lunch, and I would recommend that you move there quickly because you can get the